the question here I'm going to ask is, what can we learn from the experience of transparency in political science and British administrative law in thinking about transparency in algorithmic decision making? So we've seen, as a result of the excellent talks that we've had today, there's enormous uncertainty and a lack of clarity about what transparency for automated decision making actually means and what it requires. But it's fair to say that this normative commitment to providing transparency in decision making is certainly not new. Okay, and so what I'm going to try and do today is to consider some of the lessons we might draw from two quite different bodies of critical reflection that have had considerable experience in wrestling with legal approaches to embedding transparency in particular decision-making contexts. So the first source of critical reflection is from political science, and particularly reflections from political scientists in light of their experience of freedom of information legislation that took effect in the UK in 2005. So we've had quite a long time to think about how FOI has worked. And secondly, from British administrative law concerning the common law duty to give reasons. So these are quite different sets of reflections, different methodological approaches, and we will see that there are some differences. But despite this, I'm going to suggest that there are some really helpful shared insights that emerge from this literature which could significantly enrich the debate about transparency for algorithmic decision-making systems and open up more fruitful lines of inquiry for future research. But I don't actually have very long to speak, so what I'm going to do is something rather unusual and mostly give you kind of claims and not make the argument. I'm just going to say this is what we can glean, and then if you have questions about it, I can unpack them a bit further in the discussion time. So let me start then with lessons from political science. So as I'm sure you're all familiar with, the reason why transparency matters in democracies is because all of the power that the government exercises is from us. Okay, all of governmental power and authority is derived from its citizens, and hence governments must be accountable to the governed for the way in which that power is exercised. So this is where the political science critiques spring from. And so in their reflections about transparency for decision making and accountability, their discussions are primarily focused in terms of enabling the governed to understand and to justify how governmental power has been exercised. So the relationship between the governor and the governed can be understood as something of a principal-agent relationship, and the core concern here is the exercise of collective decision-making by government authorities on behalf of its citizens. Now, to try and give you insights from political science in 5 or 6 minutes is not something I could manage, so I've limited my sources. And so what I'm going to do instead is to share with you some insights from a book that was written by two leading political scientists, Christopher Hood and David Held. It's called Transparency, the Key to Better Governance. And this is a collection of essays that they produced in 2006 following a 2005 British Academy workshop, which they hosted to coincide with entry into force of the UK's Freedom of Information Act, published in 2006. Well, it turns out that when I was thinking about what to talk about for the purpose of this talk, I remember that, in fact, I'd written a review of this book, which was very handy and was published in 2008. I'd almost forgotten that I'd written it. And I thought, well, let me go back to that book and to that book review and to see what insights we might glean from those reflections from 10 years of experience of FOI legislation in the UK and what that might offer to contemporary and ongoing debates about transparency for algorithmic decision-making systems. So they're a very rich set of essays, and I definitely commend them to you, but it seemed to me that there are 3 themes that are especially salient for the kinds of discussions that we've been having today and that we are going to increasingly have as a society. The first one is that transparency is not everything. Transparency is not an unalloyed good. That's surprising, isn't it? You'd think as a lawyer I'd go out there and say transparency is fantastic. I do think transparency is fantastic, but it's not everything, okay? And it can come into conflict with other normative values, and this makes trade-offs between transparency and other values necessary and unavoidable. Secondly, the vital importance of sensitivity to the specific context in which transparency is allegedly required in decision making. And thirdly, and I think importantly for the discussion that we've been having today, that formal transparency measures, such as freedom of information laws, and I could say such as the GDPR, do not necessarily and inexorably translate into substantive enhanced transparency in decision-making practice, and that is my worry. So let me start then with just unpacking these claims a little bit further. Firstly, that transparency is not an unalloyed good, and it can conflict with other normative values, and so we do need to make trade-offs when that conflict arises. And so in a very fine-grained analysis, David held in an excellent essay in this book, argues that transparency can be understood as a set of contested, non-linear relationships with other values that sometimes clash and sometimes yield synergies. And so although it's true that in general transparency can contribute to the values of effectiveness, trust, accountability and fairness, it can also come into conflict with other values such as efficiency, confidentiality and privacy. Secondly, the literature also emphasises the vital importance of being sensitive to the specific context in which transparency is allegedly required. And so again, to quote David Held, to make a meaningful normative assessment of the contribution of transparency, he says, careful attention to the specific habitats in which transparency resides, as well as directions and variety is needed. And this includes attending carefully to the dynamics and effectiveness of policy instruments in which transparency measures and mechanisms are located. And so in the collection, a number of the scholars observe that sometimes transparency can jeopardise good substantive decision-making in a particular set of circumstances, and that is where speculative judgments about risk must be made, but might be hard to explain. And an example that's given is there was a discussion at one stage when, I think it was under the Blair administration, that we should publish the mortality rates of surgeons, of heart surgeons in particular, and there was a worry that if you started doing that, heart surgeons would no longer accept risky cases, because they were worried that people would misinterpret the data as you must be a bad surgeon because your patients died, when it turns out that the best surgeons are given the risky cases. So that's a nice example of when there may be a conflict between transparency and good substantive decision making. As well, some of the more kind of politically inflected critiques notice that in political bargaining, and Brexit's a nice example, sometimes transparency can undermine the capacity of the parties to reach mutually beneficial political compromise, because sometimes they need to be absolutely candid in ways that their constituencies can't completely see through to, and this can result in deadlock. So there are two sets of circumstances there where transparency might work against good decision making. Thirdly, however, and most importantly, formal transparency measures like freedom of information laws do not necessarily translate in practice into better and enhanced transparency and decision making. And the question is, why is that? Why doesn't a law just do what it's supposed to do? Very good question. Well, for a number of reasons. Firstly, sometimes people seek to avoid their obligations, and they engage in what's called circumvention practices, and they might then try to circumvent transparency obligations and engage in various informal measures of resistance. So I'm sure you're familiar with that when someone says, why don't we just have a phone call? In other words, don't, for heaven's sake, create a written record and don't put it on an email. I'm sure you've all had that experience before, because you know it becomes traceable and trackable. And indeed, sometimes you avoid creating records altogether. So there are ways in which people circumvent their transparency obligations, not necessarily for bad reasons, but it happens, and that's what happens in human communities. Secondly, not just informal resistance practices are engaged in, but there might be some formal practices of resistance, and that includes getting your lawyer to interpret the right as narrowly as possible, and therefore to reduce the extent to which that right may or that obligation might apply to you. And then, of course, there are practical measures that you can take to try and basically make it more expensive for people to avail themselves of the legal rights that are available, and that therefore effectively render them ineffective for the ordinary person. So as a result of these kinds of methods of resistance and responses and circumvention practices, measures that are formally intended to enhance transparency may fail to generate substantive transparency, with the result that the underlying justification for why we care about transparency and the substantive purpose that the law is trying to achieve is rendered utterly ineffective at best and sometimes even counterproductive at worst. And I think there's a really important lesson there for the way in which the GDPR gets implemented. There is one essay in it which is particularly scathing, and I'm sure you know Honora O'Neill, as she's well known for speaking her mind, and she writes an exceptionally scathing piece and says, she says, and this is after FOI legislation is brought into force, she says, we have a transparency illusion. She said, based on a general presumption that transparency therefore increases trust and trustworthiness in institutions, and yet for her, the growth of transparency in contemporary governance as a principle of good governance that we all kind of warm our hands around and put our hand on our heart has in fact, she said, led to a decline in trust in public officials and institutions. And why is that? And she says, it's because these formal measures of transparency have simply failed to generate meaningful, substantive transparency and instead produced merely nominal transparency. So she's not alone in this, and then there are a number of other contributors who warn of the dangers of a legalistic culture. And they emphasise the importance of attending to the practical value of these measures to applicants, to data subjects, to the people who are supposedly protected by these legal regimes, as well as an awareness of the limitations of formal transparency measures and metrics, especially given the vulnerability of these obligations to evasion or manipulation. Others similarly are concerned that within organisations, there's a risk that what can happen inside an organisation is it becomes very blame conscious. So, and lawyers are very familiar with that. It's all about covering your backside, okay? And as a result, the turn to transparency measures can become merely standard operating routines, and that means it can just become box ticking, that you say, yes, I've complied by ticking a checklist, and in practice that can create frustration and alienation for the beneficiaries of the regime. That blame avoidance concerns can start to dominate organisational responses and produce kind of tokenistic responses by leaving audit trails but which actually fail to fix the substantive problem, or you can simply avoid record keeping altogether to ensure what Hood calls collective amnesia. So that's what I'm going to say about the political science insights, and I'm now going to turn to British administrative law. And in particular, I'm going to look a little bit at the common law position on the duty of public authorities to give reasons. And so we see here that these are two very different bodies of critical reflection and thought about transparency obligations and the duty to give reasons in particular. But nonetheless, what these two bodies of reflection share is that they're rooted in the same foundational concern. That is that the power of governmental authorities derives from the governed, to whom they must justify and give an account of the way in which they exercise their power. Having said that, there are two further features that are emphasised in British administrative law that are not brought out in the political science critiques, and the first one is that public authorities must respect the rule of law. And Sandra said she was kind of surprised by that being put in the legislation, but one cannot take that for granted, okay? The requirement of legality is absolutely vital, and it is especially vital, and I know Maria shares this view, is especially vital for public authorities. They need to show a lawful basis for every single thing they do. As well as that, there's a particular concern in the case law about decisions that affect individuals, and hence specific individuals who are directly affected need to be provided with safeguards to protect their legitimate rights and interests if they are affected by public decisions, and because of recognition of the position of individuals, that might, not necessarily, but it might ground a legal duty on public authorities, depending on the context, to provide reasons for their decisions. Okay, so again, huge, very rich case law. I'm not going to try and summarise it. It's been a long time since I've read the cases. But I think there are 4 useful lessons that we can glean from the case law that's specifically concerned whether a particular individual is entitled to a legal duty to insist upon reasons from a public decision maker. So the first one, and this is one of the things I want to emphasise, especially in light of the first session that we had today, where there's been a really extensive argument in the legal literature about the so-called right to an explanation, and when does it arise, and what are its parameters, etc., etc. Well, interestingly, in administrative law, the courts have had none of that, right? They just have not done that. They have steadfastly avoided adopting a rigid approach, and they have preferred to be flexible and to attend carefully to the nature and context of specific decisions. So one of the striking features, and this might surprise you for the non-lawyers and certainly the non-British lawyers amongst you, is that in English law there is no general duty to give individuals reasons, even if you're a public authority, and that seems surprising. But on the other hand, nor is there a general right on public authorities to refuse to give you reasons. It all depends on the context and circumstances. It's a kind of classically English approach. What's the answer? Well, it all depends. On the one hand this, on the other hand that. And you might criticise it, but you know, actually, the longer I work with British law, the more I kind of think that the old chaps who used to say, oh, the genius of the common law, actually, there is genius there. There is, in fact, genius there. So a duty to give reasons might arise in the particular circumstances if it would be unfair for the authority to refuse to provide them, or if specifically required by legislation. So the question then for the public authority and for the court in deciding whether this obligation arises is whether or not imposing such a duty on the public authority would serve the underlying justifications for requiring reasons, or would mitigate against imposing such a duty, taking into account all of the circumstances and context of the individual cases. So flexibility rather than rigidity characterises the approach of British courts. Secondly, why a right to reason? So if you look at the case law, we can see that judges have made clear that there are a number of reasons why public authorities might be required to give reasons for a decision. Firstly, that it might improve decision making. Secondly, to refuse to give reasons might be unfair to the person affected. And thirdly, that the giving of reasons may support judicial review and improve transparency and accountability in government in other ways. So in short, the duty to give reasons may enhance several process values, including the value of promoting good decision-making, good outcomes, showing respect for persons, and that I think is vitally important, and 3, subjecting the administration to the rule of law. On the other hand, the court has also recognised that sometimes there are reasons not to give reasons. Why not a right to reasons in some cases? Well, sometimes in some circumstances, the giving of reasons will not serve some legally recognised process values, and so the law won't require that reasons be given, as well as recognising that giving reasons is not cost-free, in that producing reasons is an expensive chore, and anyone who's been told that we have to start giving reasons to our students in exam marking will know exactly what that means. Secondly, that they might generate pointless litigation over the wrong choice of words, and sometimes they can distort good decision-making. So there's a lovely quote from Lord Justice Sedley, which I won't read out to you. So then what it boils down to is whether it would be unfair for the public authority to refuse to give reasons, and that will depend upon whether or not giving reasons serves the underlying justification for requiring reasons or mitigating against it. 2 considerations are especially relevant: the purpose of the decision and the context. A couple of factors here that are relevant to the way in which the court makes this evaluation. Firstly, the nature of the issues to be decided, and not the importance which attaches to the matter falling to be decided. So this is a common mistake that students make, that you think if the decision is so important, we must require reasons to be given. So the decision to award somebody a job, it's very important for the candidate, but the question is, would giving reasons to that candidate as to why somebody else got the job necessarily serve process values? Not necessarily. So the court may not require reasons in that case. However, if you're being deprived of a right, you're being disciplined, you're being punished, you're being put into prison, I think you're entitled to a right to reason. So deprivation, decisions that have a deprivatory effect, generally ground a right to reasons both before the decision is made so that they can know the case against them and participate in it, and after the decision so that they can understand what has been done to them. In particular, the duty to respect persons is especially important. So sometimes the mere fact that to show somebody respect for them as persons entitled to be treated as moral agents with dignity and respect is so important that we must insist on reasons. So to give you an example, in the case of Fegeta, this was a case of a psychiatrist who made an order to compulsorily insist on antipsychotic medication being administered to a mental health detainee against his will. The first doctor prescribed the antipsychotic medication. This was backed up by a second opinion. Now, generally, courts will not interfere with clinical judgment, and so it wasn't going to change the outcome if you required reasons, because courts would not interfere with that judgment. Nevertheless, the interference with his personal and individual and physical integrity was so great that reasons would be required. And there are other circumstances, if the decision just looks wrong, if there's something so peculiar about the decision, then courts will require reasons. So what we see then, drawing these two strands of literature together, is that both of these literatures emphasise value conflict and the need for trade-offs, that context is vital, that one size does not fit all, and therefore we need to attend very carefully to the particular decisions that are at stake and the context in which they're being made. And this is not the way in which the legal literature is playing out at the moment. It's all being played out, and there's some kind of model, and if we identify the model, if circumstances X apply, then there's a right to reasons, and otherwise there's not. I think we should resist that, and I'm going to argue in favour of contextual application. I'm sure lots of you won't like that. You'll say, how on earth do we make that scalable? And I'm going to say, well, public authorities have lived with this for decades, and the sky has not fallen in, okay? We have found a way. It is good discipline for public administrators, and I don't think that it's been a disaster simply because the answer is contextual, and I think it's this sustained contextual understanding that we need to secure public trust in automated systems. One of the things that political science critiques emphasise is the importance of nurturing a culture in which explanations matter because we care about them for good normative reasons. And indeed, formal transparency requirements don't become substantive policy goals, and the literature in socio-legal studies is littered with cases where formal legal measures have not done what the policymakers have hoped because of circumvention responses, and at worst a legalistic approach might generate a box-ticking mindset, which is really not what we want. So the core policy goal is that transparency in decision-making as a general principle of good governance that is ultimately grounded upon a need to ensure that power in liberal democracies is exercised accountably and ways that demonstrate respect for persons is properly recognised, and we actually embed that into organisations, but can sometimes be overridden by other considerations. There's a larger question here, nobody has talked about it today, and it's been largely overlooked and everywhere actually, which is rooted in political theory. And that is, conventionally we draw a distinction between public and private organisations. So I've been talking about the duty of public authorities to give reasons, but Google's not a public authority, neither is Facebook or all of these other great platforms. And generally speaking, as I say to my students, if the bouncer doesn't like the look on your face, you can't get into the nightclub, and there is not a thing you can do about it, okay? So private firms have much more freedom so long as they don't contravene the law, whereas public authorities are much more restricted because their power derives from the citizens, and it's important to guard against corruption and abuse. But one of the major innovations in contemporary European data protection law is the right to data protection applies to everyone, public or private, who processes personal data, and the procedural rights which it embodies are applicable to all public and private bodies without distinction. So this is an interesting movement that is little observed, but it seems to me that before we really crack this, we need new political theory to make sense of it. We need to understand, we need to generate a new political theory for a hyper-connected, digital data-driven age, in which the role of machines and the way in which power and authority is exercised by them in combination with our data is properly accounted for within the parameters of the theory. What are the core lessons, I think? The first is that context matters. It shouldn't be one size fits all. We need to be guided substantively by why explanations matter and work towards nurturing a substantive culture in which requiring reasons is understood and respected as important and worthwhile, rather than a legalistic hurdle to be overcome or sidestepped.